The Indian real estate sector is a colossal engine of capital. Millions of homes and billions of dollars move through it annually. Yet, for decades, it operated in a regulatory vacuum, where accountability was almost non-existent. Developers utilized intricate webs of subsidiaries and opaque accounting practices. These corporate veils function to hide the diversion of capital away from the actual construction sites. This resulted in landscapes scarred by stalled, decaying structures. Everyday buyers were left holding the bag, paying mortgages on properties that would never be finished. While the investors faced financial ruin, the promoters executing these diversions grew wealthier. They operated in an environment where skimming project funds carried virtually no legal risk. That environment has been replaced. Lawmakers have overhauled the regulatory framework, arming authorities with severe, highly targeted statutory countermeasures. Promoters now face a legal framework built to identify and seize diverted capital, using specific mechanisms to remove their corporate protections and recover stolen wealth. In the Octopus Structure, promoters create a massive network of interconnected shell companies. Homebuyer money is siphoned out of primary accounts and funneled into these shadow entities, disguised as material advances. Once laundered offshore, the core project is starved of cash. To dismantle this, authorities deploy the Prevention of Money Laundering Act, enforced by the ED. Under the PMLA, the Enforcement Directorate bypasses the corporate shield entirely. They trace the round-tripped money and directly attach the personal assets of the promoters involved. Furthermore, Section 447 of the Companies Act ensures this diversion is prosecuted as systemic corporate fraud, which carries multi-year, non-bailable prison sentences. By removing the shield of the corporate structure, these laws expose the promoter's own savings and property to the weight of a federal fraud investigation. The second major scheme is Proxy Land Aggregation, used to maneuver around agricultural laws. To execute this, developers deploy vast amounts of untaxed black money, silently purchasing massive, illegal land banks in the shadows. To avoid detection, the land is never registered to the actual company. It is secretly held in the names of proxies, drivers, office peons, or local farmers. The developer maintains total invisible control over the entire parcel through an unregistered power of attorney. The countermeasure for this is the Benami Transactions Prohibition Amendment Act of 2016. This act grants the government absolute authority to immediately confiscate these proxy properties. For the developer, the penalty is total. The state takes the land, and there is zero compensation. Because the act allows for seizure without payment, a promoter can lose a multi-million-dollar land bank through a single court order. The third and most common scheme is the Commingled Treasury. Developers treat distinct project accounts as a single, massive slush fund. The massive cash flow from a fast-selling mid-income housing project is actively siphoned away. Instead of laying bricks, these funds are diverted to prop up the toxic debt of failing luxury hotels. Predictably, the original housing project stalls out completely. This leaves everyday citizens trapped, continuing to pay EMIs for apartments that have ceased construction entirely. To stop this bleed, lawmakers introduced a crucial 2018 amendment to the Insolvency and Bankruptcy Code. This amendment executed a radical power shift. It officially classified everyday homebuyers as financial creditors. A unified group of stalled homebuyers can now legally drag the offending corporate entity into the National Company Law Tribunal. The NCLT has the authority to strip the promoters of their company and kick them off their own board of directors, handing control of the empire over to a resolution professional. The power dynamic has inverted. The victims now possess the statutory authority to execute a hostile corporate takeover. The powerful legal mechanisms that once shielded and protected developers from the consequences of their fraudulent accounting have been completely dismantled. Attempting these traditional real estate schemes no longer results in mere fines or temporary suspensions. Fraud now leads to the forfeiture of project control, the loss of personal wealth, and multi-year prison sentences. The legal burden has shifted. It is now the promoter's responsibility to prove their accounting is clean or risk the total loss of their enterprise. For investors and homebuyers, understanding these legal tools is the ultimate defense. You must audit the corporate structures to protect your capital. Rigorous investigation and statutory knowledge are now required to navigate this landscape. Stay vigilant.